Hello everyone, I'm delighted to be with you today to discuss insider dealing under the Securities and Futures Ordinance, which I'll talk about as the SFO. I'll begin today by looking at the insider dealing provisions of the SFO, including the defences and consequences of breaches. I'll also look at some of the recent cases and finish with a summary of the SFC's proposal to broaden the insider dealing regime. So the SFO contains civil and criminal market misconduct offences under Parts 13 and 14 of the SFO, respectively. 6 types of market misconduct are covered: insider dealing, false trading, price rigging, disclosure of information and prohibited transactions, disclosure of false and misleading information inducing transactions, and stock market manipulation. Civil cases of market misconduct are dealt with by the Market Misconduct Tribunal, while criminal cases go before the courts. In broad terms, insider dealing typically occurs when a person connected with a Hong Kong listed company, such as a director or member of staff, has privileged information which could impact the company's share price when it becomes publicly known, and trades or procures someone else to trade the company's securities or derivatives so as to make a profit or avoid a loss before the information becomes publicly available. Or someone obtains information from someone else they know to be connected with a listed company, and they trade or procure the other person to trade in the company's securities or derivatives so as to make a profit or avoid a loss before the information becomes publicly available. The SFO definition of insider dealing covers 7 circumstances. The first is when somebody with inside information deals in shares of a corporation with which they're connected. Here, insider dealing happens when a person connected with a listed company has information which they know is inside information in relation to that company, and that person either deals in the company's listed shares or their derivatives, or in those of a related company, or counsels or procures someone else to deal in these listed securities or derivatives, knowing or having reasonable cause to believe that the other person will deal in them. The second situation is when a person who's contemplating or has contemplated making a takeover offer for a listed company and knows that the information that the offer is contemplated or is no longer contemplated deals in the company's listed securities or derivatives or in those of a related company otherwise than for the purpose of the takeover, or counsels or procures someone else to deal in these listed securities or derivatives other than for the purpose of the takeover. This provision is designed to stop, for example, a director of a company which is about to launch a takeover bid from telling his friends to buy shares in the intended target in order to make a profit when the price of those shares inevitably rises. It doesn't stop the director of the bidder from buying shares in the target or counselling or procuring others to do so in what's known as a dawn raid, where the sole purpose of such purchases is to facilitate the takeover itself. The provision is also designed to catch, say, a director of the bidder who sells short in the target when they know, but the public doesn't know, that the bidder is not going to increase its offer price at the end of the initial offer period, but will instead let the offer lapse. Thirdly, insider dealing happens when a person connected with a listed company has information which they know is inside information in relation to the company, and that person discloses the information directly or indirectly to another person, knowing or having reasonable cause to believe that the other person will use the information to deal or counsel or procure another person to deal in the company's listed shares or derivatives or in those of a related company. This will cover someone who deliberately leaks confidential information with a view to someone else, either the person tipped off or a third party using the information to make a favourable deal by trading the securities on the Hong Kong Exchange. Fourthly, insider dealing also happens when a person who's contemplating or has contemplated making a takeover offer for a listed company and knows that the information that the offer is contemplated or no longer contemplated is inside information, discloses the information directly or indirectly to another person, knowing or having reasonable cause to believe that the other person will use the information to deal or to counsel or procure another person to deal in the company's listed securities or their derivatives, or in those of a related company. Fifthly, it will also be insider dealing when a person has information which they know is inside information in relation to a listed corporation, which they received directly or indirectly from a person who they know is connected with the company and who they know or have reasonable cause to believe held the information as a result of being so connected, and they deal in the company's listed securities or their derivatives or in those of a related company, or counsel or procure someone else to deal in these listed securities or derivatives. This covers the recipient of the leaked information who uses it either by dealing themselves or by counseling or procuring someone else to deal. Insider dealing also happens when a person has received directly or indirectly from someone they know or who they have reasonable cause to believe is contemplating or no longer contemplating making a takeover offer for the listed company, information to that effect which they know is inside information in relation to the company, and deals in the company's listed securities or their derivatives or in those of a related company, or counsels or procures someone else to deal in such listed securities or derivatives. Finally, insider dealing also occurs when a person who knowingly has inside information in relation to a listed company in any of the circumstances I've just talked about, then either counsels or procures someone else to deal in the company's listed securities or the derivatives, or in those of a related company, knowing or having reasonable cause to believe that the other person will deal in these listed securities or derivatives outside Hong Kong on an overseas stock market, or they disclose the inside information to another person knowing or having reasonable cause to believe that they or someone else will use the inside information to deal or counsel or procure the other person to deal in the company's listed securities or derivatives or those of a related company outside Hong Kong on an overseas stock market. For this final type of insider dealing, the SFO extends the mens rea element. The person disclosing the inside information must know or have reasonable cause to believe that the person to whom the inside information has been disclosed or some other person will use the inside information. The SFC is currently proposing to amend the mens rea element of the other types of insider dealing taking place through disclosure of inside information to also cover this or some other person using the information. I'll talk about the SFC's proposals later. These provisions on dealing outside Hong Kong and an overseas stock market extend the scope of the insider dealing regime to dealings in securities dual listed in Hong Kong and overseas. Where insider dealing involves securities that are listed on foreign exchanges and not dual listed in Hong Kong and overseas, the court may rely on the offence of using fraudulent or deceptive devices in transactions in securities, futures, contracts or leveraged forex trading under Section 300 of the SFO, rather than Section 270 or Section 291. This was shown in the case of SFC against Young Bik Fung and others, a case where two solicitors, Betty and Eric, were found guilty of illegally profiting from inside information. Betty had been seconded from a law firm to a Hong Kong bank to assist with the bank's takeover of a company listed in Taiwan, Hsinchu International Bank. Discussions took place between the two banks between August and September 2006, and a tender offer was announced on the 29th of September 2006. Betty was aware of information about the tender offer and the offer price, 24.5 Taiwan dollars per share, prior to the public announcement on the 14th of September 2006. On the 20th of September 2006, a new securities account was opened with Tai Fook by the third defendant, one of the solicitor's sisters, and between the 21st to the 29th of September, the defendants collectively injected substantial sums into the Tai Fook account and went to considerable lengths to raise the funds through loans, overdrafts, and liquidating portions of their investment portfolios. Then, between the 22nd to the 29th of September, the third defendant bought 1,576,000 shares at an average price of 16.99 New Taiwan dollars. On the 29th of September, the tender offer was announced, and the third defendant accepted the offer for all the shares and distributed the profit, around Hong Kong dollars 2.69 million, in proportion to their contributions. Due to the extraterritorial feature of the case, the court relied on Section 300 of the SFO, which prohibits fraudulent or deceptive schemes in transactions involving securities, as the securities involved were listed in Taiwan, and so the conduct was outside the scope of Hong Kong's insider dealing regime. However, since the offer to buy the securities was made in Hong Kong, Section 300 applied. The court also accepted that the third defendant's acceptance of the tender offer in Hong Kong would also have brought the case within the scope of Section 300. Ultimately, the court held that Betty's conduct, misusing material price-sensitive information and knowingly breaching dealing restrictions which applied to her, amounted to a scheme or act of deception. The Court of Final Appeal upheld the court's ruling, stating that Section 300 could be applied in respect of securities listed outside of Hong Kong, provided substantial activities constituting the crime occurred within Hong Kong, which they did in this case. As I'll talk about later, in June 2022, the SFC published a consultation paper in which it proposes to extend the SFO insider dealing provisions to include insider dealing carried out in Hong Kong involving securities listed on overseas stock markets or their derivatives. I'll now briefly go through the key definitions relating to insider dealing. First, securities. These are broadly defined in Part 1 of Schedule 1 to the SFO and include shares, stocks, debentures, loan stocks, funds, bonds or notes, rights, options or interests in any of these, certificates of interest or participation in, temporary or interim certificates for, receipts for, warrants to subscribe for or purchase any of the securities which I referred to at the beginning, interest in a collective investment scheme, any interest, rights or property commonly known as securities, whether in the form of an instrument or not, and structured products not falling within the definitions I've just talked about. A structured product is an instrument under which some or all of the return or the amount due, or both the return and the amount due, or the method of settlement is determined by reference to one or more of changes in the price, value or level, or a range within the price, value or level of any type or combination of types of securities, commodity, index, property, interest rate, currency exchange rate or futures contract. Changes in the price, value or level, or a range within the price, value or level of any basket of more than one type or any combination of types of securities, commodity, index, property, interest rate, currency exchange rate or futures contract, or the occurring or the non-occurrence of any specified event or events, excluding an event or events relating only to the issuer or the guarantor of the instrument, or to both the issuer and the guarantor. And a structured product, which is a regulated investment agreement or involves any interest, rights or property prescribed or of a class or description prescribed by notice under Section 392 of the SFO as being regarded as structured products. The SFO's insider dealing offences apply only to securities listed on the Hong Kong Stock Exchange at the time of the dealing in question. The definition of listed securities includes issued unlisted securities, provided that at the time of the insider dealing, it's reasonably foreseeable that they will be listed and they are subsequently in fact listed, and unissued securities, provided that at the time of the insider dealing, it's reasonably foreseeable that they will be issued and listed and they are subsequently in fact issued and listed. As I'll talk about later, the SFC is currently proposing to extend the definition of listed securities to also include overseas listed securities or their derivatives. The definition of corporation includes the large number of companies which are listed in Hong Kong but are incorporated abroad. A person connected with a corporation, an insider, is someone who is on the inside track, who has access to information about a company by reason of their relationship with it. Sections 247 and 287 define an individual as connected with a company if they are a director or employee of that company or a related company, which includes shadow directors. The definition also includes substantial shareholders. That's a shareholder who has an interest in 10% or more of the issued voting share capital in the company or a related company, as well as a person who has a position which may reasonably be expected to give them access to inside information concerning the corporation by reason of a professional or business relationship, or the fact that they're a director, employee, or partner of a substantial shareholder of the company or a related company. A person will also be deemed an insider if they have access to inside information by virtue of being connected, as I just mentioned, with another company, where that information relates to a transaction, actual or contemplated, involving both companies or involving one of them and the listed securities of the other or their derivatives, or to the fact that such a transaction is no longer contemplated, or they were connected with the company as I just described at any time within 6 months preceding any relevant dealing. A company is connected with another company if any of their directors are or employees are so connected. Under sections 248 and 288, any public officer or member or employee of certain bodies who in their capacity as such obtains inside information about a company will be deemed to be connected with that corporation. Looking next at the SFO's definition of related corporations, two or more corporations will be related corporations of each other if one of them is the holding company of the other, a subsidiary of the other, or a subsidiary of the holding company of the other. Corporations are also related where the same individual controls the composition of the board of directors of one or more corporations, controls more than half of the voting power at general meetings of one or more corporations, or holds more than half of the issued share capital, excluding any part which carries no right to participate beyond a specified amount on a distribution of either profits or capital of one or more corporations. Each of the corporations I just described and their respective subsidiaries are regarded as related corporations of each other. Section 2451 of the SFO defines inside information in relation to a company as specific information about the company, a shareholder or officer of the company, or the listed securities of the company or their derivatives, which is not generally known to the people who are accustomed or would be likely to deal in the listed securities of the company, but which would, if it were generally known to them, be likely to materially affect the price of the listed securities. Inside information can include information about changes in a company's shareholders or officers and about rights attaching to listed securities and derivatives over those securities. The same definition also applies to Hong Kong listed companies' obligation to publicly announce inside information under Part 14A of the SFO. Information will be specific if it's capable of being identified, defined, and unequivocally expressed. In Firstone International Holdings Limited and Chinese Estates Holdings, Chinny Alliance Limited, and Gilbert Holdings Limited, it was determined that information will be sufficiently specific, quote, if it carries with it such particulars as to a transaction, event, or matter, or proposed transaction, event, or matter, so as to allow that transaction, event, or matter to be identified and its nature to be coherently described and understood. Information doesn't need to be precise in order to be specific. According to the SFC guidelines on disclosure of inside information, it's not necessary that all particulars or details of a transaction, event, or matter are precisely known. Information may still be specific, even if it has a vague quality, and may be broad, which allows room, even substantial room, for further particulars. For instance, information that a company is having a financial crisis would be regarded as specific, as would contemplating a forthcoming share placing, even if the details are not known. However, specific information is to be contrasted with mere rumours, vague hopes and worries, and with unsubstantiated conjecture. Inside information is information that's not generally known to the market. That's people who are accustomed or would be likely to deal in the company's listed securities. Rumours or media speculation relating to a company doesn't mean the information is generally known, a distinction which the SFC has noted. Information relating to a corporation that appears in the media, analyst research reports, or electronic subscription databases cannot be assumed to be information that is generally known to the market, even where media reports are widely circulated. In determining whether this kind of information is generally known, corporations must consider not only how widely the information is disseminated, but also the accuracy and completeness of the information and whether the market can rely on that information. Section 2451 further requires that inside information must be information which would, if it were generally known to the wider investing public, to be likely to materially affect the price of the listed securities. So the information must be price sensitive. It's not sufficient that the information should simply affect the price of the securities. The effect must be material. Information that's likely materially to affect the price of a company's securities is information which may well materially affect the price, i.e., it's more likely than less likely that the price will be affected materially. The test of whether the information is likely to be materially affect the price is necessarily a hypothetical one, as it's almost always applied at the time the information becomes available. Under Section 249 of the SFO, a person deals whether they act as principal or agent. Agreeing to deal and buying or selling the right to deal will also be dealings under the SFO. Sections 271 and 292 of the SFO set out defences to insider dealing, where a person can establish that they fall within certain categories. This is when the dealing, counselling or procuring was made for the sole purpose of acquiring qualifying shares as a director or intended director of a company, in good faith in performance of an underwriting agreement for the listed company's securities or derivatives, in good faith as a liquidator, receiver or trustee in bankruptcy. A company, for example an investment bank or a sponsors firm, will have a defence if it can demonstrate that there were effective arrangements in place, often known as a Chinese wall, to ring-fence any inside information in the possession of any of its directors and employees, and each person who took the decision for the company to deal, counsel or procure a dealing in the listed securities or derivatives in question did not have the inside information at that time and had not received advice from those in possession of the information. It's a defence if the purpose for which a person dealt in or counselled or procured another to deal in the listed securities or their derivatives or disclosed information did not include the purpose of securing or increasing a profit or avoiding or reducing a loss, whether for themselves or another, by using the inside information. It's also a defence if a person dealt or counselled or procured another to deal in a corporation's listed securities or their derivatives if they acted as agent, did not select or advise on the selection of such listed securities or derivatives, and they did not know that the person for whom they acted as agent was connected with that corporation or had inside information. It will be a defence if the dealing occurred off-market in Hong Kong and the person dealing in listed securities or their derivatives and the other party entered into the dealing directly with each other, and at the time of the dealing the other party knew or ought reasonably to have known of the inside information. It will also be a defence if the dealing occurred off-market in Hong Kong and where a person counselled or procured another person to deal in listed securities or their derivatives. They counselled or procured the other party to enter into the dealing directly with them, and at that time the other party knew or ought reasonably to have known of the inside information. It's a defence where a person dealt in listed securities or their derivatives but did not counsel or procure the other party to deal, and at the time of the dealing the other party knew or ought reasonably to have known that such person was a person connected with the corporation. This defence operates on the assumption that people who transact with someone they know or should know is a company insider should be on notice that the other party may be insider dealing, and so make adequate inquiries with the insider before dealing with them, and perhaps negotiate terms as to the disclosure of inside information. A person who counselled or procured someone to deal in listed securities or their derivatives will have a defence if they can establish that the other person did not counsel or procure the other person to the dealing to deal in the listed securities or derivatives, and at the time they counselled or procured the other person to deal, the other party to the dealing knew or ought reasonably to have known that the other person was a person connected with the corporation. This gives a defence to someone who counsels or procures someone to deal in the same circumstances as a defence is available to someone who deals themselves in the circumstances I just described. It's a logical extension of that defence and would, for example, protect an investment bank who introduced a prospective purchaser to a substantial shareholder of a listed corporation who the bank thought might want to tender or divest their shareholding and advise the shareholder on the sale. A defence is available to someone who dealt or counselled or procured someone else to deal in a corporation's listed securities or their derivatives where the person acted in connection with any dealing which was under consideration or was the subject of negotiation, or in the course of a series of such dealings and with a view to facilitating the dealing or the series of dealings, and the inside information was market information arising directly out of their involvement in this dealing or series of dealings. Market information is defined to include facts such as that there has or is to be, or that there has not been or is not to be a dealing on listed securities or their derivatives, or that any such dealing is under consideration or negotiation. The quantity and price or price range of the listed securities or their derivatives, and the identity of the people involved. This gives a defense to someone who trades with knowledge of their own trading intentions or activities, and also to those who simply execute or facilitate a trade on their behalf. This defense caters for the situation in which a person whose trading activities might be price-sensitive information, for example, a substantial shareholder and therefore a connected person, increases their stake in a listed company. Without such an explicit defense, a person dealing with inside information about their own trading activities is technically insider dealing. Dealing subject to the rules of a recognized clearinghouse will have a defense where the deal was entered into by the clearinghouse with a clearing participant for the purposes of the clearing and settlement of a market transaction. Sections 272 and 293 provide a further defense where a trustee or personal representative dealt in or counselled or procured a dealing in listed securities or their derivatives on advice obtained in good faith from an appropriate person who did not appear to them to be a person who would have been involved in insider dealing if such person themselves had dealt in the listed securities or their derivatives. Sections 273 and 294 provide a defense where a person dealt in listed securities or their derivatives in the exercise of a right to subscribe for or otherwise acquire such securities or derivatives, which was granted to them or which was derived from securities held by them at a time when such person was not aware of any inside information. Looking now at another case, SFC against Yu Hoi-ying, Charles and others in 2018, where the Court of Final Appeal ruled in a 4-1 decision for the SFC and clarified the innocent purpose defence. The respondents were Mr. Yu and Ms. Wong, who held 6 million shares and 10 million shares respectively in Asia Telemedia Limited. ATML owed a debt of 58.08 million Hong Kong dollars to Goodpine Limited. In April 2007, Goodpine Limited served a statutory demand on ATML and stated that it would issue a winding up petition against ATML if the debt was not repaid within 21 days. While this was known to Mr. Yu and Ms. Wong, it had not been announced to the public. At the same time, shares in ATML experienced a price surge. Mr. Yu took advantage of the surge by selling all of his 6 million ATML shares in May 2007, making a net profit of 5.3 million Hong Kong dollars. Ms. Wong sold her 10 million ATML shares between February and June 2007 and made a net profit of 5.1 million Hong Kong dollars. The SFC alleged in proceedings before the Market Misconduct Tribunal that the respondents' knowledge of Goodpine Limited's statutory demand to ATML constituted inside information and that they engaged in insider dealing when they relied on that information to dispose of their ATML shares at a profit. Mr. Yu and Ms. Wong relied on the innocent purpose defense, saying that the reason for their disposals was the speculative surge in ATML's share price at the time, and not their knowledge of the inside information, which was Goodpine Limited's issue of a statutory demand and threat to wind up ATML. They argued that they believed that ATML's financial situation would be dealt with behind closed doors eventually and would not influence the market. The MMT and later the Court of Appeal accepted their defence. However, that defence was rejected in the Court of Final Appeal's 4-1 decision in favour of the SFC. Whether Mr. Yu and Ms. Wong could rely on the defence turned on what constituted use of the inside information. The Court of Final Appeal reasoned that using inside information means turning the possession of inside information into action. Mere withholding or non-disclosure of inside information is insufficient to show use of the inside information. The inside information had to be exploited for financial advantage. The respondents knew that the price of the ATML shares was artificially high because of the inside information they possessed, and they disposed of the shares to profit from that knowledge. The Court of Final Appeal's ruling seems to suggest that officers of a ListCo are considered to be using inside information and can't rely on the innocent purpose defence if they possess inside information which is not publicly known when they deal in the company's securities. The respondents' belief as to what might happen in the future, i.e. that ATML's financial situation would be dealt with behind closed doors, was considered irrelevant. The defence doesn't apply as long as the inside information played a role in the decision-making, regardless of how big or small a role the inside information had in the decision-making process. The implication of the judgment is that officers of listed companies who have inside information should avoid dealing in the company's shares until the inside information has been publicly announced. Having allowed the SFC's appeal, the Court of Final Appeal remitted the case to the Market Misconduct Tribunal to deal with the question of appropriate sanctions on the basis that Mr. Yu and Ms. Wong had been found culpable of market misconduct. In March 2021, the Market Misconduct Tribunal made various orders against Mr. Yu and Ms. Wong, including a 3-year disqualification order against Ms. Yu and an HKICS disciplinary referral order against Mr. Wong, and in respect of both of them, a 3-year cold shoulder order, cease and desist orders, disgorgement orders, and government and SFC costs orders. I'll talk about MMT proceedings and orders shortly. So turning now to the consequences of insider dealing. The SFO creates dual civil and criminal insider dealing regimes. The Market Misconduct Tribunal conducts civil proceedings and, where appropriate, imposes civil sanctions. It's an independent body chaired by a judge or former judge who sits with 2 members and a presenting officer appointed by the Secretary for Justice when conducting proceedings. It's inquisitorial and is entitled to direct that the SFC carry out further investigations and report their findings to the MMT. Under the SFO, the presenting officer is a lawyer whose role is to present evidence to the MMT. They should be more like a prosecuting counsel rather than a counsel assisting the tribunal, and they should be independent. If it appears to the SFC that market misconduct has or may have taken place, it can institute proceedings before the MMT under Section 252 of the SFO. The purpose of MMT proceedings is to determine whether any market misconduct has taken place, the identity of people who have engaged in market misconduct, and the amount of any profit gained or loss avoided as a result of the market misconduct. The MMT might identify a person as having engaged in market misconduct if they've carried out any market misconduct, the market misconduct was carried out by a corporation of which such person is an officer with their consent or connivance, or another person engaged in market misconduct and they assisted or connived with that person in the carrying out of the market misconduct, knowing that such conduct constituted or might constitute market misconduct. The Market Misconduct Tribunal makes its filings on the civil standard of proof. It therefore needs to be satisfied that a person has engaged in market misconduct on the balance of probabilities rather than beyond reasonable doubt, which is the criminal standard of proof. The MMT has powers to receive any evidence, whether or not the evidence would be admissible in civil or criminal proceedings, and has wide powers to compel the giving of evidence and to prevent the publication of information about the evidence it receives. A person is not excused from complying with the requirement of the MMT to give evidence on the ground that to do so might incriminate them, Section 2534, and such compelled self-incriminatory evidence may be considered by the MMT. At the end of any proceedings, the MMT can, under Section 2571 of the SFO, impose a range of sanctions on any person found to have committed market misconduct. These sanctions include a disqualification order, cold shoulder order, cease and desist order, disgorgement order, costs orders, or a disciplinary referral. A disgorgement order is an order to pay to the government an amount equal to the amount of any profit made or loss avoided as a result of the market misconduct. Failure to comply with a disqualification, cold shoulder, or cease and desist order is a criminal offence punishable by a maximum fine of 1 million Hong Kong dollars and/or up to 2 years imprisonment. Any person who is dissatisfied with the finding or determination of the MMT can appeal to the Court of Appeal, but only in respect of a point of law or with the leave of the Court of Appeal on a question of fact under Section 266. In China Huiyuan Juice Group Limited, Ms. Su Min was prosecuted for buying around 8.6 million shares of China Huiyuan Juice Group Limited, a China fruit juice producer listed on the main board of the Hong Kong Exchange, on 6 different occasions through 4 different companies ahead of the announcement by the company that it would be acquired by Coca-Cola. Ms. Sun made a profit in excess of 55.1 million Hong Kong dollars when she sold all her shares in the company within 48 hours after the public announcement of the Coca-Cola takeover. Ms. Sun had close connections with the management of the company, but there was no direct evidence proving that she received inside information on the Coca-Cola takeover. She denied having any inside information or knowledge of the takeover. The SFC's case against her centered around the circumstantial evidence and inferences from handwritten notes on the Coca-Cola takeover found in Ms. Sun's secretary's diary, which were taken in a meeting between Ms. Sun, her husband, her secretary, and the COO of Ms. Sun's shipping company. The SFC was unable to identify from which connected person the inside information came. The secretary was unable to recall how the information was collected or whether it was passed to her by her employer. The MMT said that if the identity of the connected person who passed on the inside information could not be ascertained, the MMT would decide based on all available evidence whether a compelling inference could be drawn that the inside information must have been from an unidentified connected person and that Ms. Sun must have known of that fact. Some of the handwritten notes in the secretary's diary concerned PRC antitrust law. The Market Misconduct Tribunal considered that an ordinary investor would not have considered PRC antitrust law issues unless they knew of the potential Coca-Cola takeover. On that basis, the MMT inferred that the information came from an insider, even though the insider's identity could not be ascertained. The MMT also considered that the inside information in the diary must have come from Ms. Sun, or she must have known of the information. The MMT therefore rejected the secretary's evidence that she was unsure whether she had passed on the information to Ms. Sun. All forms of market misconduct, including insider dealing, are liable to prosecution as a criminal offence under Part 14 of the SFO, which carries a maximum penalty of 10 years imprisonment and a fine of up to 10 million Hong Kong dollars. The court may also make disqualification, cold shoulder, and disciplinary referral orders, and non-compliance with any such order is an offence liable to a maximum fine of 1 million Hong Kong dollars and up to 2 years imprisonment. A person will not be subject to the double jeopardy of both civil proceedings under Part 13 and criminal proceedings under Part 14 for the same conduct. The SFO provides that a person who has been subject to criminal proceedings under Part 15 may not be subject to MMT proceedings if those proceedings are still pending or if no further criminal prosecution could be brought against that person again under Part 14 in respect of the same conduct and vice versa. The decision as to whether to take civil or criminal proceedings in relation to suspected market misconduct is made by the Secretary for Justice based on two criteria, there being sufficient evidence and the public interest. The SFC may also institute summary criminal proceedings before a magistrate for less serious market misconduct offences, although the Secretary for Justice is able to intervene in the SFC's conduct of any such proceedings. The SFO provides a private right of civil action against any person who's committed market misconduct or any offence under Part 14 in favour of anyone who's suffered a pecuniary loss as a result, unless it's fair, just and reasonable that the perpetrator should not be liable. So a person commits market misconduct if they've carried out any market misconduct, a company of which they're an officer carried out the market misconduct with their consent or connivance, any other person committed market misconduct and they assisted or connived with that other person in carrying out the market misconduct, knowing that such conduct constitutes or might constitute market misconduct. It's not necessary for there to have been a finding of market misconduct by the MMT or a criminal conviction under Part 14 before bringing civil proceedings. Findings of the MMT are, however, admissible in the civil proceedings as prima facie evidence that the market misconduct took place or that a person engaged in market misconduct, and a criminal conviction constitutes conclusive evidence that the person committed the offence. The courts are able to impose injunctions in addition to or in substitution for damages. Section 279 of the SFO imposes a duty on all officers of a company to take reasonable measures to ensure that proper safeguards exist to prevent a company from acting in a way which would result in a company carrying out any market misconduct. The definition of an officer of a company includes a director, including a shadow director and any person occupying the position of a director, manager or secretary of, or any other person involved in the management of the corporation. This could, in principle, cover supervisors and anyone else with management responsibilities. Under Section 258, where a company has been identified as having been engaged in market misconduct and the market misconduct is directly or indirectly attributable to a breach by any person as an officer of the company of the duty imposed on them under Section 279, the MMT may make one or more of the orders I talked about earlier in relation to that person, even if that person has not been identified as having engaged in market misconduct themselves. Anyone who suffers pecuniary loss as a result of market misconduct has a right of civil action to seek compensation. Under Section 390 of the SFO, where it's proved that an offence committed under Part 14 was aided, abetted, counselled, procured, or induced by, or committed with the consent or connivance of, or attributable to the recklessness of any officer of the corporation or any person purporting to act in any such capacity, that person, as well as the corporation, is guilty of the offence and liable to be punished accordingly. Under Part 9 of the SFO, any regulated person who's guilty of misconduct or who, in the opinion of the SFC, is not a fit and proper person to be or to remain the same type of regulated person is subject to a widened range of disciplinary procedures. Misconduct is defined to include any contravention of the SFO or of the terms of any licence issued or registration made under it. The SFC can revoke or suspend a person's licence in respect of all or any part of the regulated activities for which they're licensed, or may impose a fine not exceeding the greater of 10 million Hong Kong dollars or 3 times the amount of the profit gained or loss avoided by the regulated person as a result of their misconduct or such other conduct which led to the SFC's opinion that such person is not fit and proper. The SFC may also impose prohibition orders preventing an offending person from, among other things, applying to be registered or licensed under the SFO. Approvals granted to responsible officers may also be suspended or revoked. People covered by these provisions include corporations licensed under the SFO, their responsible officers and people involved in their management, authorised financial institutions which must be registered with the SFC to conduct regulated activities, for example, securities dealing, asset management, and so on, their executive officers, people involved in the management of their regulated business, and individuals named in their register as carrying out a regulated activity are also subject to the SFC's disciplinary regime. Section 213 of the SFO enables the Court of First Instance on the application of the SFC to grant orders or remedy breaches, to prevent or remedy breaches of the SFO and other relevant ordinances. Section 213 is remedial in nature and is concerned with handling the adverse consequences of actual or potential market misconduct. Proceedings are stand-alone proceedings and are intended to provide remedies to protect the interests of those involved in the impugned transactions. Section 213 also covers aiding, abetting, or assisting, counselling, or procuring another person to commit a breach of the SFO, inducing by threats, promises, or otherwise another person to commit a breach of the SFO, directly or indirectly being knowingly involved in or a party to a breach of the SFO, or attempting or conspiring with others to commit a breach of the SFO. The available remedies include injunctions and orders requiring the person to take steps to restore the parties to a transaction to the position they were in before the transaction, or restraining or prohibiting someone from acquiring, disposing of, or dealing in any property. The Court of First Instance has to satisfy itself that it is desirable to make one or more of the orders and that the orders will not unfairly prejudice anyone. A case worth mentioning is that of SFC and Tiger Asia, a US-based hedge fund, which confirmed the power of the CFI to make orders sought by the SFC under Section 213 on the basis of insider dealing or other market misconduct, without there being a prior finding by the MMT or criminal court. Tiger Asia received confidential and price-sensitive information regarding placements of shares of China Construction Bank and Bank of China, and then took short positions in the shares of the two companies before the placings were announced to the public and made a substantial profit. Tiger Asia also manipulated the CCB share price during the closing auction session. The court ordered Tiger Asia and the two senior officers to pay around 45.3 million Hong Kong dollars to investors affected by the insider dealing. Another example is the case of the Hong Kong against Du Jun, which demonstrated that the SFC can pursue both criminal proceedings for market misconduct and a Section 213 order. Du Jun, a former MD of Morgan Stanley, was convicted of insider dealing in the shares of China Resources Holdings and sentenced to 6 years imprisonment and fined 1.7 million Hong Kong dollars. Separately, in Section 213 proceedings, the court granted a restoration order against Du Jun, ordering him to pay 23.9 million Hong Kong dollars to 237 affected investors, intended to restore counterparties to their pre-transaction positions. In June 2022, the SFC released a consultation paper on proposed amendments to enforcement-related provisions of the SFO. I'll refer to that as the consultation paper. In Part 3 of the consultation paper, the SFC set out its proposed amendments to Parts 13 and 14 of the SFO to widen the territorial scope of Hong Kong's insider dealing regime. Consultation responses were due by the 12th of August 2022, and depending on the responses, an amendment bill will be introduced into LegCo. The current insider dealing regime doesn't apply where the relevant securities are only listed outside of Hong Kong or their derivatives, even where the acts specified in sections 271 or 291 of the SFO happen in Hong Kong. So the SFC has dealt with cases of suspected insider dealing in Hong Kong of overseas listed securities or their derivatives by providing intelligence to the relevant overseas securities regulators or relying on the fraud or deception market misconduct provisions under Section 300 of the SFO. For example, in the Young Bik Fung case, which I mentioned earlier, that's the case involving the two Hong Kong solicitors where the securities were listed in Taiwan, the SFO insider dealing provisions didn't apply as the relevant company wasn't listed in Hong Kong, although the dealing occurred in and information was acquired in Hong Kong. In that case, the CFA, as you will recall, determined that there'd been a contravention of Section 300 of the SFO, and on that basis, the Court of Final Appeal granted orders under Section 213 of the SFO. However, the SFC thinks that to be a significant conceptual difference between the type of conduct that Section 300 prohibits as compared to that prohibited by the insider dealing provisions. Section 300 aims to deal with acts of fraud or deception involving transactions between specific people rather than conduct that deceives and misleads the market as a whole. On the other hand, the insider dealing prohibitions aim to prevent the conduct of taking advantage of inside information to make trading gains. As a result of this conceptual difference, the nature and amount of relief available is different. For example, in the Young Bik Fung case, as Betty, a fiduciary, had defrauded or deceived her principals, her employer, the law firm, and its client, the Hong Kong Bank, the Section 213 restoration order granted based on the Section 300 contravention was to return the profits from the illicit trades to the bank. The bank was a victim of the fraud or deception. However, if the restoration order was based on a contravention of the insider dealing provisions, that's Section 270 or 291, the order would have been calculated on the basis of restoring affected investors impacted by the illicit trades to the position in which they were before the relevant transactions were entered into. In another case, a Hong Kong licensed intermediary dealt in the securities of an overseas listed entity prior to the announcement of a placing exercise. The dealing occurred when in possession of inside information, which was provided by another Hong Kong-based licensed intermediary. Apart from the mechanics of trading, the acts related to the offence occurring in Hong Kong. However, the SFC says in its consultation paper that as it didn't have adequate evidence to establish that the suspect had engaged in any fraudulent or deceptive acts in respect of the relevant transactions, it couldn't take action under Section 300 of the SFO. So this case draws attention to the fact that the elements of the Section 300 offence and those of the insider dealing prohibitions are very different. Fraud and or deception are key elements of Section 300, but are not elements necessarily of the insider dealing prohibitions. The SFC is therefore proposing to extend the SFO insider dealing regime to cover any act which takes place in Hong Kong involving overseas listed securities or their derivatives. The SFO insider dealing provisions currently don't explicitly apply to insider dealing involving Hong Kong listed securities or their derivatives, where the acts specified in Section 270 or 291 occur outside of Hong Kong. Due to the lack of express provisions stipulating the territorial scope of the insider dealing regime, in each individual case, the SFC applies the common law test of whether a substantial measure of the activities of the crime have taken place within Hong Kong, so as to determine the territorial jurisdiction. According to the consultation paper, over 60% of insider dealing cases handled by the SFC between 2017 and 2021 related to insider dealing carried out outside of Hong Kong involving Hong Kong listed securities or their derivatives. The SFC is therefore proposing to extend the SFO insider dealing regime to cover any act which takes place outside of Hong Kong involving Hong Kong listed securities or their derivatives. The proposed expansion of the scope of the SFO insider dealing provisions would also align the provisions with the SFO's other market misconduct provisions. Those expressly prohibit acts carried out in Hong Kong or elsewhere which affect Hong Kong's financial markets, as well as acts carried out in Hong Kong which affect overseas financial markets, subject to the acts also being unlawful in the relevant overseas jurisdiction. The proposals also aim to align Hong Kong's insider dealing laws with those of other major common law jurisdictions, including Australia and Singapore, which cover overseas conduct in respect of local issuers' securities and local conduct in respect of issuers' overseas issuers' securities. Another point is that the implementation of the proposals would allow the SFC to tackle insider dealing occurring in Hong Kong involving A shares that are traded through Stock Connect. I'll now talk about the SFC's proposed amendments to the SFO. First, the SFC proposes to amend the definition of listed in sections 2452 and 2852 of the SFO, so as to also include overseas listed securities or their derivatives. The definition currently only covers securities listed on a recognized stock market, which is the stock market operated by the Hong Kong Stock Exchange, or their derivatives. The SFC is also proposing to add a new section to parts 13 and 14 of the SFO to expand the territorial scope of insider dealing to also govern any acts of insider dealing involving Hong Kong listed securities or their derivatives, regardless of where they occur. Overseas listed securities or the derivatives of any one or more of these acts occur in Hong Kong. The SFC also proposes to repeal sections 272 and 2917 of the SFO, which currently extend the scope of the insider dealing provisions to dealings in securities dual listed in Hong Kong and overseas or their derivatives, as these sections would become redundant. Also, the SFC proposes to add a new subsection to sections 282 and 306 of the SFO, so that in relation to the proposal to govern overseas listed securities or their derivatives, where any act occurs in Hong Kong, a person would only be liable if their conduct is also unlawful in the relevant overseas jurisdiction. This is consistent with the position for other types of market misconduct. It's also proposed to amend section 2715 of the SFO, that's the off-market dealings defence, so that the defence is also available in respect of insider dealing involving overseas listed securities or their derivatives. The SFC is additionally proposing to align the two formulations of the mens rea element in relation to insider dealing. The mens rea element of sections 272b and 2917b, which apply to dual listed securities or their derivatives, is satisfied where the person disclosing the inside information knows or has reasonable cause to believe that the other person to whom the information is disclosed or some other person will deal in the listed securities or their derivatives. On the other hand, the mens rea element of the other subsections of sections 270 and 291, which apply to securities listed only in Hong Kong or their derivatives, is satisfied where the person disclosing the inside information knows or has reasonable cause to believe that only the other person to whom the information is disclosed will deal in the listed securities or their derivatives. The formulation of the mens rea element that applies to Hong Kong listed securities or their derivatives is therefore narrower, as it does not cover some other person dealing. The SFC therefore proposes to align the two formulations by adopting the formulation in sections 272b and 2917b. So that brings me to the end of the formal part of this webinar. Thank you, and see you again soon.